The High Court stated that the matter raised important legal issues, the nature of the power to consider and determine applications for medical parole, and the role of the Medical Parole Advisory Board. Zuma was sentenced to 15 months imprisonment for contempt of court for failing to obey an earlier order of the Constitutional Court requiring him to appear before the Commission of Inquiry into allegations of state capture. Former Correctional Services Commissioner Arthur Fraser released Zuma after serving less than 2 months of his sentence against the recommendation of the Medical Parole Advisory Board.
For any person who has been sentenced and who is serving that sentence in correctional facility, for that person to qualify to be released on medical parole, there are 3 requirements that should be met, and these 3 requirements are succinctly packaged in Section 79 of the Correctional Services Act.
Fraser argued that Zuma suffered from multiple comorbidities and that correctional services could not offer the specialized treatment he required.
Section 79 requires that a person should be terminally ill. Yes, so if you apply Section 79, there may be a different finding, because now terminally ill may not apply in terms of what seem to be the medical reports. But Section 75 grants the National Commissioner those powers. So I think that's where the difference is.
In papers before the SCA, Zuma argues that the former Correctional Services Commissioner had an obligation to protect him as an inmate. However, the respondents, the DA and the Helen Suzman Foundation, contend that the Medical Parole Advisory Board is the statutory body to recommend whether medical parole is granted or not. Makhala Masiteng, SABC News, Bloemfontein.